Hello and welcome back to the lecture series, The Good Lawyer. This is lecture number 3. If you haven't watched the first two, please go ahead and watch those first. In the first one, I explain the 5 basic principles that we will talk about during this course, The Good Lawyer, and the second lecture is about confidentiality. And today we will talk about the second of the 5 principles, partiality. If you remember what I told you in the first lecture, partiality comes automatically, more or less, from the task that a lawyer has. In our online chat discussion last Thursday, we talked about the role of the lawyer, that a lawyer, in brackets, an attorney, has a specific role to play within the legal system and within the system of legal proceedings. And that role is that the lawyer advises a client and or represents a client in proceedings before court. So from this task, the core task of a lawyer, comes the principle of partiality, which means that a lawyer has to have the interest of the client in mind by whatever advice he gives and by the representation, difficult word, by the representation in court. So the core principle of partiality is directly linked to the core task of the lawyer. There are a couple, if we look at the scope of partiality and the limitations, so the interest of the client is at the center of the attorney's work. One of the questions, of course, is what is the limit to that? Does a lawyer just have to do everything a client asks, whatever that might be? And the obvious limitations, of course, are limitations in terms of what is legally allowed. So no illegal activity or criminal activity. I'm struggling with the words today. I'm sorry about that. So no illegal activity or criminal activity is, of course, within is allowed within the context of partiality, even if those activities might serve the interest of the client. It might very well be that it would be in the best interest of the client, if you have a criminal case, if all the witnesses were dead who saw your client kill his wife. But I mean, I don't even have to mention that, I guess. It's obvious that your activities as a lawyer, they always have to fall within the scope of what is legal and what isn't criminal. So that's rather obvious. But there are other questions with regards to the scope and limitations of partiality that are less obvious and also less easy to answer. And they fall under under the topic of, does a lawyer just have to do just everything a client asks if it's legal and if it's legally sound? I can't really answer that question with a yes or no, and we will come back to that again in the next lecture, number 4, when we talk about independence. As you might remember from the first lecture, independence is also one of the 5 basic principles, and it means that a lawyer has to be independent from outside influences. And you can imagine that this a request of independence can clash, as it were, or at least it feels as if it can clash with the principle of partiality. Because some lawyers would tend to define their role as what we a bit negatively call the hired gun. And that doesn't mean that lawyers shoot people, but in a more, not in a literal sense, but in a more, non-literal sense, a lawyer as a hired gun, which means that the client is the boss, and if the client wants something and it's legally possible and it's within the framework of the procedure or whatever advice you give, then the lawyer should just do that. Again, we will talk about this more in the next lecture and in our online chat session when we talk about the relationship between partiality and independence. But it is something that you have to keep in mind. It's a question that every lawyer has to ask themselves in the framework of answering the question, how far do I go with the principle of partiality? Another important aspect of partiality is what it means in regards to one client compared to other work or other clients. Because I'm sure you've all heard of the conflict of interest rule, which means that as a lawyer, you are not allowed to represent clients' cases where there are conflicting interests. So, for instance, if you had a labor, you are the lawyer in a labor dispute and you are the lawyer for the employer, you cannot, in that same dispute, also represent the employee. There are exceptions to this rule. For instance, if both parties sometimes because they want to save cost, ask you to represent them both, there is a possibility to waive this conflict of interest rule, that it's not allowed to represent both sides of one conflict. But it's comparable with the confidentiality rule that we talked about last week, that even if the client waives the confidentiality, you still have to make up your own mind as a lawyer whether it is in the best interest of clients to represent them both. There are cases in which this is certainly possible to represent them both. For instance, in a divorce case, when there is an amicable divorce and but the divorce papers need to be filed with the court, but there is no struggle between the parties, it is not impossible to represent both husband and wife, or wife and wife, or husband and husband, so both parties. But it's something that is the exception to the rule of conflict of interest. It's also important that this limitation, the conflict of interest limitation, is pretty broad. So, for instance, it is if you have this same labor conflict that we talked about before just now, and you represent the employer, and the conflict has been solved, and then an employee of the same employer asks you to represent her in a different case. So you would say, well, the first case is finished, so why not? But the rule of conflict of interest goes further than one case. So it could very well be that even if you decide once to represent the employer, that you are bound for all the cases that might follow to be on the employer's side, even if he doesn't ask you to represent him. And you can't represent the employee, even in a new case. This rule is I don't want to say not as strict, but it has to be decided case by case, depending on the circumstances of the new case, depending on both parties, what they say. You have, of course, to disclose to your potential new client that you represented his opponent in a different proceedings. And if the employer, for instance, says, no, I don't want that because you know stuff about me, and despite confidentiality, I just don't want that, then you are bound by that. So the conflict of interest rule has to be interpreted quite broadly. And I know that a lot of firms, especially bigger firms, who cannot keep track of each of the cases that each of the 100 lawyers do, they have special computer software where the cases are logged, including the opponent, and when a new case comes along, it's run through this computer software to see whether there might be a possible conflict of interest. Important to remember is that in the end, it is your decision as a lawyer, after you disclosed everything, whether you feel in these sort of borderline cases that it is okay for you to represent a client. That is especially important in criminal cases, because it's in some countries it's really strictly forbidden to represent more than one defendant in one case. But in most countries, like in the Netherlands, there is no such rule. So if you have a case, for instance, a fraud case, a Ponzi scheme or whatever, and there are 10 suspects, you are in principle not, it's not forbidden to represent all of them or 5 of them. There is no rule. But of course, you have to ask yourself, after the first client came in, when then the second and the third and the fourth comes in, is there a possibility that these defendants might clash with each other? So it's important to keep that in mind. There is, as I said, it's the lawyer's responsibility to keep that in mind and to reflect upon that, and to decide whether there is a possible conflict of interest between various defendants accused in one criminal case. It's not the district attorney or prosecutor's task. So you will find, for instance, that sometimes prosecutors say, well, you cannot defend the second accused in this case. That's a conflict of interest. Your answer should be, that's very interesting that you tell me that, but it's up to me to decide and not up to you. So that's also important, that other parties involved cannot decide for you. It's your decision. And if we just look at the case of various defendants in one criminal case, it could very well be that in the beginning it seemed as if there's no problem, they all have sort of the same interest, but that changes in the course of the proceedings. For instance, if one of the defendants wants to decide on a different strategy and wants to become a witness for the prosecution in order to maybe get some leniency and get a lower sentence. And that obviously clashes with your first client who doesn't want that. In Holland, in the Netherlands, the rule is then, unfortunately, that you have to stop working for both clients. So not only the one that came later and thus now wants something that is in direct conflict with your first client, but you have to get both clients new attorneys. That's why it's so important from the very start to look at possibilities whether defendants could possibly come in conflict with each other. And another important aspect, if you have various clients in the same case on the same side, so various employees in a labor law conflict against one employer, or in a criminal case, various accused in one case, that it is possible then, if you are not working by yourself, but if you are in a law firm, if one client is represented by you and the other client is represented by a colleague. You will remember in the confidentiality rule, it was quite different. Confidentiality cannot be breached within your office, within the same lawyers of one office. But with partiality, that is a very, let's say, a very personal principle. In other words, it's really just about you personally, individually, as a lawyer, with regards to that client. So if your colleague defends or represents a client on the same side, but a different client, that is less of a problem. Of course, you then have to employ what we would call Chinese walls in the office, so that you don't discuss the case of your client with the colleague who represents the other client in the case. But just so that there's no misunderstanding, it's not possible within a firm to represent both sides of a conflict, arguing, well, it's just individual. So if my colleague represents the employer, it's no problem if I represent the employee. No, that's not how it works. So for the conflict of interest between opposing sides, the law looks at the office as a whole, But with regards in, at least in Holland, again, I stress that's for the Netherlands. But if you look at possible conflict of interest of various clients on the same side of the conflict, then it is a solution that you divide up the work between colleagues. The basic rules of partiality, of course, are to ensure that the client's interest comes first. That's what we talked about when we, in the first lecture, when we looked at the principal task of a lawyer, and that's what we look at when we try to find the scope and the limitation of this principle of partiality. So the interest of the client is at the center, is at the core of this principle. And as I already indicated, there is a possible clash, that's maybe too big of a word, but a possible, conflict between the partiality principle and the independence principle. If you look at what is in the best interest of the client, who determines that? Who is the boss in this relationship, client and lawyer? And to go a little bit further in with this question and trying to answer that question, even though, as I said, there is no yes or no answer, we will go to the next lecture, lecture number 4, in which we will discuss the principle of independence. So this is it for partiality. Thank you for watching. I hope you understood everything. And as you know, we will discuss partiality, independence, and who is the boss, and how should you look at the lawyer as a hired gun in our online chat sessions on Thursday. But for now, on to lecture number 4, independence.